From Feature Story News in Washington, I'm Kevin McAleese. US President Donald Trump is expected to give his approval to the House Intelligence Committee to release a controversial memo before the end of the week. The FBI has warned they have grave concerns about the document, to the point that some are reporting FBI Director Christopher Wray is seriously considering resigning over the growing political crisis. The president sees the memo as evidence that the Russia investigation is nothing but a witch hunt. The memo argues the evidence to grant a special wiretap of a Trump campaign aide was tainted. Democrats are convinced the 4-page document is a GOP attempt to discredit the FBI and the Russia probe. Senior Republican House Speaker Ryan said he thinks the process should go forward.
This is about us holding the system accountable and reviewing whether or not FISA abuses occur. The government has been given extraordinary power over citizens' civil liberties. It is our job to make sure that the process is followed properly. And if it's not followed properly, then we need accountability. I say lift all of it out, so long as we're not involving sources and methods, so long as we're not revealing sources and methods to protect our national security. The more transparency, the better, so that the people of this country can see that their civil liberties are being protected, that the Constitution is being followed. That's why we think sunshine, transparency, and accountability is the correct antidote for this.
The eldest son of late Cuban President Fidel Castro has died as a result of an apparent suicide, according to Cuban state media. Fidel Angel Castro Diaz-Balart was found dead in Havana on Thursday morning. The 68-year-old, who is a scientific advisor of the state council, had reportedly been struggling with depression and had been hospitalized. Known as Fidelito, he bore a strong physical resemblance to his late father, who ruled Cuba for over 5 decades. A new development in the Rohingya crisis. The Associated Press news agency has confirmed dozens of people buried in at least 5 mass graves in Myanmar. The exclusive AP report contradicts the Myanmar government's denials that Rohingya Muslims are being massacred and points to the possibility of there being more mass graves. Our UN correspondent Li Ling Tan has the details.
Men half buried in mass graves, their faces disfigured by acid or bullets. This was among numerous witness accounts provided to the Associated Press. The news agency has confirmed at least 5 mass graves containing dozens of bodies, based on interviews with refugees in Bangladesh, as well as time-stamped cell phone videos. The AP report suggests a systemic slaughter of Rohingya Muslims in Myanmar and adds weight to international suspicions of genocide. The UN Special Rapporteur on Human Rights in Myanmar, Yang Hee Lee, who has been barred by the Myanmar government from entering the country, is urging the European Union and the US to impose sanctions.
From bureaus worldwide, this is FSN.
This is the Scotsman.
And this is Drew.
And coming up on the next Ale Evangelist show, we're going to talk about our top 5 regular drinkers. Now, Andrew, you're a regular drinker at several places, aren't you?
None that I'll admit to.
Okay. But we are actually going to be talking about the beers that you would want to drink regularly. We're going to do our top 5 beers that you would drink regularly. Feel free to go to our Facebook fan page and let us know what your regular drinkers are. And you can listen to ours on the next Ale Evangelist show.
This is Jay from the Jay's Politics Blog podcast, and you're listening to the Podcast 99 Network.
Captain's log. Using the light speed breakaway factor, the Enterprise has moved back through time to the 20th century. We are now in extended orbit around Earth, using our ship's deflector shields to remain unobserved. Our mission? Historical research.
I think he hurt Joe Frazier. I think Joe is hurt. Frazier's hurt. Angie Dundee, Ali's trainer, right next to me, is saying it. You may hear him. Down goes Frazier. Down goes Frazier. Down goes Frazier. The heavyweight champion is taking the mandatory 8 count, and Bowman is as poised as can be in a neutral corner.
We have just received a bulletin from the Associated Press from Texas that reports that former President Lyndon Johnson is dead. Lyndon Johnson has died. According to the bulletin, former President Lyndon Johnson, he was 64 years old, has died, according to his press secretary. The report only says that Johnson was stricken at his ranch in Texas. He died this afternoon at Brooke General Hospital. Repeating that bulletin that has just arrived, former President Lyndon Johnson is dead of a heart attack at the age of 64. We'll have more details in the program as we get them. The other major story today, aside from the death of Lyndon Johnson, the tragic death, and the hopes for peace in Vietnam, is the decision of the United States Supreme Court. It handed down a historic decision about abortion.
In a landmark ruling, the Supreme Court today legalized abortions. The majority in cases from Texas and Georgia said that the decision to end a pregnancy during the first 3 months belongs to the woman and her doctor, not the government. Thus, the anti-abortion laws of 46 states were rendered unconstitutional.
To raise the dignity of a woman and give her freedom of choice in this area is an extraordinary event.
I think that the judgment of the court will do a great deal to tear down the respect previously accorded human life in our culture.
We the people.
We the people of the United States.
We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America.
In the summer of 1787, 55 men would gather in the city of Philadelphia. They had been tasked with fixing the government of the United States. Over those 4 months, they would debate, discuss, argue, and eventually create a document that attempted to prove that men could rule themselves not by a king, but by law. This is the story of those men, those times, and the legacy of what they did. It's a time we set aside to read, discuss, consider the Constitution of the United States, what it says, why it says it, what it means, and what it meant then, how it's been interpreted, and how it's applied to our nation from the beginning down through today. This is Constitution Thursday. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Those are the words of the 9th Amendment to the United States Constitution. It provides our starting point for the evening. It will not be the ending point. January 22nd, 1973 was a Monday. The world and the nation were a much different place back then. In Colorado, the approaching weekend promised a good deal of fun with friends for your gracious host. George Foreman wasn't selling grills. He was punching George Frazier in his. The nation would be stunned when President Lyndon Johnson suddenly passed away. And making it to all the news shows that evening, the Supreme Court's ruling striking down laws in Texas and in Georgia which banned abortions and began to shape the political landscape that would divide the nation ever since that day. Welcome aboard, my friends. Glad to have you with us today for the first live broadcast of Constitution Thursday since September 20th, 2013. It was a long time ago, and we've come a long way. There's still some bugs in the system that we're working out. There's supposed to be a live chat room, and as far as I know, there is, but I cannot access it. Not sure why. Don't really understand it. But when I click on it to go to it, I just get the Windows circle, where it just sits there in circles and circles and circles. And I didn't do what I meant to do. I'm a firm believer, going all the way back to the days of USS Michigan, that every 6 hours you reboot your computer. Well, I didn't do that. I got busy around 7:30 when I intended to do it and made coffee instead. So if you're in the chat room, I can't talk to you. Sorry. The only way to get a hold of me directly is via the text machine. And that, of course, area code 209-565-DAVE, 565-3283 in the 209 area code. Otherwise, everything else seems to be working as far as I can tell. I guess we'll find out as we go through the evening. The over-under on interruptions by Ben is probably 2 as well. Monday, January 22nd, 1973 was it was, to me, it's one of those moments that is embedded in history. There are very few days from my childhood that I can remember the day clearly. There are events that I remember. There are times that I remember. There are things, people, but very few days where I can say, on this day, I did this thing. And later on in the day, this happened, and then this happened, and then this happened, and this microphone stand that I bought from China just got in my way. Sorry. If you watch the test show, you know why that's a big deal. Very few days that I can really point to that I can say, I remember that sequence of events very clearly. Monday, January 22nd in Denver was a cool day. I was 9, getting ready to head to 10. We were excited. The world was changing. Kids today won't understand this, but there was a lot of discussion about the Vietnam War finally coming to an end. In fact, tomorrow, January 23rd, President Nixon will announce the end of the Vietnam War. He will announce that peace accords have been signed in Paris, and then a few days later, he will announce the actual end of the war on Saturday. But coming up tomorrow, the peace accords are going to be signed. Right now, as we're sitting there talking, as we're going to school that morning, as we're looking forward to the weekend, all those things are going on, and the president is announcing those things. The day was, as I said, somewhat cool. It was, as I recall, and everything I see of that day, I see it in black and white because we had black and white television, and my mom was doing laundry. And I remember very distinctly her reaction when the news came, the bulletin came, and we had been watching, I believe it was NBC News. That's why I picked that clip, because that's the one we were watching, that the president, the former president, Lyndon Johnson, had died. Now, my parents were no fans of President Johnson, but he was a significant figure in American history up to that point. I mean, he had been for quite some time, both in the Senate, then as vice president, now as president. He was literally the driving force, I guess, in a lot of ways behind the space program, and he was gone like that. And it was so surprising because he was relatively young, 64 years old. You don't think of Lyndon Johnson as being young because when you see him, he's like, granite, but he was relatively young. I mean, I'm 54 and I'm thinking to myself, he died at 64. Oh, I don't like to think in those terms, but at any rate, the shock, and I remember the gasp from my mother when that news bulletin came across. We were watching the news, of course, because of the news from the Supreme Court that day, which was that Roe v. Wade, along with another decision, had been issued. And I guess in that era, and it's hard to understand this today, because in the day of information, we find out stuff before it even happens sometimes. There's so much information flying around. There's so much stuff for us to constantly know that it's hard to imagine that you could hear a rumor of something, maybe on a news report on the radio or something, but you didn't really believe it until you sat down at in the Mountain Time. It was 5 p.m. Turned on the national news, and there it was with either Walter Cronkite or whoever did the other news stories, the other news stations. And I don't remember the guy's name. I can see him because I watched the video the other day, but I can't remember his name. At any rate, I can remember the shock that he had when he was handed the bulletin about Johnson dying. And of course, for boxing fans, this was a big day because we were waiting for Frazier versus Foreman. And at that point, Foreman was just a challenger. Joe Frazier was the Mike Tyson of his day. And of course, Ali was already in the wings waiting. And nobody really expected Foreman to win. And certainly nobody expected a 2-round knockout. But it was a different world, like I said. And when this news finally came, and when Cronkite and the others explained to us that abortion was now legal in the United States of America, there was a distinct sense of a significant change in America on that day. I don't think we had any idea at that point the degree to which it would change. I don't think a single court decision has ever divided the nation the way that Roe v. Wade has, which is strange to me in some ways because it has skewed in a lot of ways our understanding of what the court did and why it did it, which is part of the problem. Now, a long time ago, I got told by people who had been in talk radio much longer than I had, that there were subjects that you just avoided. You didn't talk about religion because you're going to say something that will upset somebody. And as soon as you do that, you're going to be in trouble. Well, okay. And that happened to me. Literally, I think it was the fourth day of Afternoons Live. We got into religion. I didn't. One of my guests did. And the next day there was a stack of emails and messages on my boss's desk about a half-inch thick, demanding that I be fired for insulting a religion. Be that as it may, I learned that lesson. I don't really care, though. I mean, if you can't talk about religion, what can you talk about? The other thing I was told was never talk about abortion. Now, I'll tell you, the guy that told me that was one of the most accomplished chat show hosts in the history of the game. You maybe you've heard of him, maybe you haven't. Neil Bortz was on my show when he retired because I had listened to him pretty intently in Atlanta. And subsequent to that, he's written a lot of books. Neil was one of those guys. He used to say, there's no sense in talking about it because you're not going to change anybody's mind. People who are anti-abortion are anti-abortion. People who are pro-abortion are pro. And they're oil and water. They're never going to mix. You're not going to change anybody's mind. It's not going to happen. And really, I guess in some schools of talk radio, that's a good thing because then you can just generate a whole lot of calls and you can argue and complain. But that's not really, in a lot of cases, it's certainly not what I'm trying to do. And so I always kind of hesitated to get into it, not because it's not a valid subject, but because, again, all you're going to do is piss off half your audience. And that's what I'm kind of afraid of tonight. So I want to say this up front. I am not pro-abortion. I am against abortion. I would not have one. My wife and I had very long and deep discussions when she was pregnant with Ben about what if. One of the reasons we had the amniotesis test wasn't because we wanted to know if we should abort, but because we wanted to know if there were any potential problems, and we wanted to be prepared for that. We had decided we were not going to abort. My baby sister, I've told you this many times, my baby sister is Down syndrome with numerous, almost innumerable medical issues. And my parents didn't know that. There was no test that they had done back then, and so they didn't know. And now that I'm sitting here thinking about it, the day that this ruling came out would have been very early in the pregnancy of my mother for my baby sister. At any rate, and I'm just thinking about that. That's one of the reasons I love doing live shows as opposed to podcasts. Anyway, the point is that I would never do it. I would also be very hesitant, personally, to interject my positions and my beliefs on someone else who I believed had diligently considered these things and decided to do something that I would not have decided to do. I'm very firm in my belief that it's not my place to do that. And so I would not. Having said all of that, this argument of Roe v. Wade is important for us to understand, and it's important for us to get past sometimes the moral arguments of what's going on, of life and death here. It's important for us to look at what the court did and said in the context of the Constitution, and then ask the question, did they get it right? Because if we can answer that question, then maybe we can take on some of the other issues with a little bit more, I don't know what the word I'm looking for is, savvy, a little more understanding, a little more focus on exactly what it is that we're trying to accomplish. It's not that, again, you can get into the debates, life, death. You can get into the debates of, they do surgery on 20-weekers now. I get all that. My wife is a labor and delivery nurse, and believe me, I hear every day the stories of all that stuff. I know it all, which comes out really wrong. I don't mean I know it all. I mean, I know all of those arguments. That's not what I want to focus on tonight. It's not what I want to talk about tonight. There's a place for those arguments. Tonight, I want to talk about how did the court come to such a decision in January of 1973. When you consider the entirety of this ruling, when you consider all of those things, there's a tendency, and I kind of asked this question of some folks last week. Over the past few weeks, I've been really kind of getting ready for this. And if you ask people, what did the court do in Roe v. Wade? Was it a reasonable decision? Was it a sound decision? How did they reach this decision? A lot of the response you get, particularly on the political right, is the court just made up something out of whole cloth. They just completely invented. They just, as I once said, they just moved a letter in the 14th Amendment and went, oh, look, there's a fundamental right. Pa-ba! And said, okay, you have the right to abortion. That's the way we tend to think of it. The problem is, of course, that's not what really happened, is it? And if we're intellectually honest with ourselves, and if we go back and say, yeah, let's think about this for just a moment. Let's see what's going on with it. And let's figure out why things happen the way they do. And of course, in order to do that, you have to go back into history, which I always love to do. There was a time in this country when abortion was, well, commonplace, but illegal. I don't think you have to think too hard about this. I mean, you go back in history, as the judges did in Roe v. Wade, and they talked about abortion in Rome. They talked about abortion in virtually every country, civilized or otherwise, that have ever had it. But particularly with regards to what we would call, civilized society, and how abortion had taken place in those societies. And what the court noticed, and what they sort of dealt with, was the idea that there had been a shift in the United States of America. Abortion was illegal, except in the cases of raced, but that's not even a word, raced. What does that mean? That's me combining, that's my brain going faster than my lips will move. In the case of rape or incest, and in the case of the danger to the life of the mother. So those were permissible. And in fact, there were women who fabricated tales that they had been raped or incest had been committed and had abortions. And rather than cracking down on them and say, well, you're lying, the government just sort of turned its eyes and went, okay. Now remember, this was prior to Roe v. Wade, so all of these were state laws. These were not federal laws banning this. All of this was state, and 46 states had laws doing this. The city of Washington, D.C. had a law that was similar to most of these laws. It allowed for abortion in the case of rape or incest, danger to the mother, and specifically, though, went after the providers where they found to be conducting abortions that violated those conditions. So what ended up happening was a man named Vulich. I think I'm pronouncing that right. Vulich, or Volch, I guess is a better way to put it, which again opens up all kinds of stuff, and I get it. But the man's name was Volch, Milan Volch. He was an abortion provider in the District of Columbia. Several times he had been sued by the city the District of Columbia for providing services that were abortion, and they were not necessary. The government deemed they were not necessary for the life or health of the woman in accordance with the DC law. Mr. Volch challenged the law as being unconstitutionally vague with regards to the term health. What does that mean? What is health? And who decides what health is? Is that decided by the doctor? Is it decided by the patient? Is it decided by the District of Columbia City Council? Who gets to decide that? And Volch, who had been sued multiple times under this law, decided to appeal it up the chain as unconstitutional. Federal District Judge Gerhard Gessel agreed. He looked at this and said, health is vague as defined by this law. What is it? What is health? And decided that it is vague. You're going to have to be more specific than all of that. And so his suits were thrown out. The law was declared unconstitutional by the federal district judge. Of course, Washington, D.C. appealed this to the Supreme Court, where it made its way to the Supreme Court in 1971. Now, that is, as you may notice, 2 years prior to the ruling in Roe v. Wade. To this time, in 1971, it was the only abortion case to ever come before the Supreme Court, and it would be the last one to come before the Supreme Court before the Roe v. Wade. Justices had to look at two things. They had to look at whether or not they had the jurisdiction to decide the case. Now, that's a related issue that we could spend a lot of time on. I don't want to. There was another case that was up there at the same time where they were trying to decide jurisdiction, whether they had it. All you really need to know at this point with regards to this is that they decided that, yes, we do have jurisdiction to decide this case. The second one, and more important to our cause this evening, was that the court had to decide whether or not the law, the DC law, was in fact unconstitutionally vague. The arguments were really, what does it mean? Justice Black, Hugo Black, said that health was not vague. Lower courts have construed it fairly concretely to mean physical as well as psychological health. Okay. The other justices thought it's not as clear cut as that. And ultimately, the court decided against Mr. Volch. They ruled, Black, Berger, Douglas, Stewart, and White agreed that the law was in fact not unconstitutional because it wasn't vague, because health in their view meant physical and psychological well-being. In that case, Volch lost the case. You got to understand that. The district court decision was overturned. He was prosecuted by the District of Columbia, but there was some critical things that came out of that case. One was the court's decision, the ruling, treated abortion as a surgery, not something else. In other words, in the court's view, in discussing health, an abortion became a surgical equivalent of a hernia operation or a heart transplant or any of those normal functions of surgery that you would expect a doctor and a patient to discuss. The court seemed most to care about these granting sufficient leeway to allow for a doctor's professional judgment as to whether or not the case needed to happen or not, whether it needed to go forward. This was 2 years before the ruling in Roe v. Wade would be issued. And you need to follow that, because it's an important element of this when you're thinking about how the court is thinking. There's another element that enters into this, which comes in a 1965 case that Hugo Black had been vehemently in the dissent on. And this was the Griswold case, which had to do with contraceptives in the state of Connecticut? In other words, could people who are married use contraceptives? Now, I don't want to get titillating here because I don't know who's listening or watching, but if you think about this, all right, what are we talking about here? We're talking about condoms, and we're talking about pills, and we're talking about devices to prevent contraception. In Connecticut, in 1965, those were illegal. Let that rattle around in your brain for just a moment. Again, it was a much different world way back when. If you were to consider for a moment, why would these things be illegal? You might begin to see some of the issues here that are coming up. Why would these things be illegal? What things would influence the idea that contraceptions should be illegal? What would do that? Well, of course, what you're going to come up with is very quickly and very simply, you're going to come up with religious objections. The religious objections to this are going to create a situation wherein these things are being made illegal by the state legislatures. Well, the court looked at this, and the argument that was put forward was, this is privacy. 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 Now, you won't have to swing a dead cat on a 3-foot string in today's world to get an argument about privacy. Do we have a right to privacy or not? Yes or no? Thumbs up, thumbs down. Do you have a right to privacy? Yet, as Justice Black pointed out in Griswold, there is no right to privacy in the Constitution of the United States. It doesn't say it. It does not say the right of the citizens to be private shall not be infringed. The government cannot intervene, cannot impede, cannot put itself, no government intrusion is permitted, as one of the other justices would write. So how did we get that? Because in Griswold, obviously, they determined that there was a right to privacy. Well, it came from this idea, interesting that we just had a lunar eclipse. It came from this idea of penumbra. It's the word they use, penumbra. Penumbra. You know what that is, right? It's a shadow. So you get the main shadow from the Earth, and then you get this not quite as dark shadow that kind of spreads out. It's that not quite as dark shadow. It's called a penumbra in scientific terms, if I can use that. And it's that penumbra of rights that the justices decided, emanating from the 14th Amendment. I know we said we were starting in the 9th Amendment, but stay with me for a minute. It's that 14th Amendment's penumbra that allowed for privacy, this right for privacy. Now, Black argued that if there was a right to privacy, it had to be found in the 9th Amendment, but it wasn't. It wasn't there. In fact, what he complained about in his dissent in Griswold was that based on the way the court is treating this, based on the way the court is going with this, in essence, what we are doing, and let me read this to you, the judicial reading of rights into it, he cautioned, would make the court's members a day-to-day constitutional convention. In other words, by creating these rights or discovering these penumbra of rights, he was essentially fearing that the court would become a convention that happened every day for 6 months of the year and then went on its way. Of course, the problem with his statement is that the court is a day-to-day convention. That's what it does. That's how it functions. It takes in, was it intended to be this way? We could have that argument till we're blue in the face. But clearly, since Madison versus Marbury, since John Marshall, this is what the court has functioned as, a day-to-day convention on the Constitution. And by the time we get around to Volch being decided, the court realizes that there's been a fundamental shift in America, and that instead of now prosecuting the abortion providers, some states, Texas, Georgia, have started going after the women themselves. Now think about that again for just a moment. Let that rattle around in your brain and go, wait, instead of going after the doctors, however you want to look at it, they're in fact going after the women who, for whatever circumstances and whatever decision, as I said in the first segment, I'm not going to judge that. It's not my place. You can if you feel the need to, or if you want to, it's your prerogative. I will not. The governments of certain states started going after them, specifically in Texas, where they would go after the woman who would become Doe, and in Georgia at the same time. Now, the intent of the prosecutors in those states was to apply pressure, good cop, bad cop pressure, to apply pressure to these women and get them to spill the beans on where these abortion providers were and what they were doing, and so that they could kind of catch those. But of course, the problem was if they wouldn't play ball, as they say in Johnny Dangerously, play ball. If they wouldn't play ball, the prosecutors were left with literally no option except to go after the women even harder. And this is what they started to do. Well, one of the women felt that this was an invasion of her privacy. And through a long set of circumstances that we can go through if you want or not, I ended up appealing and ended up claiming that the law in Texas was unconstitutional. And of course, she would go down in history as Roe. It's not her real name. Her real name, of course, is hang on, I got to look. I sometimes my brain stops working and like, I know her name. What's her name? ... Prior history guy, Norma McCorvey, decided that this was unconstitutional and would challenge the law in Texas. She had attempted to obtain an illegal abortion, found that the facility had been closed down by the police, and she was encouraged to lie about it. She was told that she should say that she was raped, say it was incest, but nobody would believe her because, well, A, it's Texas, and B, they had no police report to back that up. So you didn't file a police report saying you were raped. There's no proof that makes your abortion illegal. Again, not arguing the morality of abortion or not abortion. That's not what I'm discussing. We're looking at procedure here. How did we get from point A to point B? How did we get from a penumbra to a constitutional right? In 1970, her lawyers filed in North District of Texas. The child was born and put up for adoption. The 3-judge panel in Texas declared unanimously the Texas law was unconstitutional. They said, nope, privacy, vagueness of health, this law is unconstitutional, and they struck it down. Well, of course, much like DC, the state of Texas appealed. Same thing happened in Georgia. Georgia appeals, and we go to the Supreme Court of the United States. This august body where people sit and listen to cogent arguments discussing whether or not this is right or that is right. The justices ask questions. If you've ever listened to it, and I highly encourage you to do so, one of the things that I really do appreciate about Chief Justice Roberts, is that he has made the audio arguments available. Again, sometimes they're hard to follow, but they're there. But one of the things you will be surprised about is there are numerous attempts at humor by both the justices and by the attorneys presenting. There are a lot of laughs. There are a lot of puns. There are a lot of interplay between them that you will see is very light considering the gravity of the situation that they are in. And of course, when Roe v. Wade went to the Supreme Court, and by the way, I don't think I said this, the day after Volch was decided, the Supreme Court decided to hear, they accepted Roe v. Wade. Okay. And in 1970, it went to the Supreme Court. They delayed action. They wanted to settle some other cases about jurisdiction. They wanted to settle some other cases about this. But finally, in December of 1971, the case went before the court. Now, I know what you're saying. December 71. That's like a year and a month before they would issue the ruling. Yeah, it is. Don't they normally rule it? They hear it and whatever, and then they issue the ruling in June. Yeah, normally that's what happens. But this case is anything but normal. December 13th, 1971, they were scheduled to argue, but two justices retired, Black and Harlan. Berger asked a couple of other justices to determine whether they should be heard as scheduled. They felt that the cases were straightforward applications of some other cases, and they decided that despite two justices retiring and not having been reseated, they should go ahead and hear it. Okay? And so the justices sit and the attorneys show up. And a guy by the name of Jay Floyd, representing the state of Texas, stood up in front of the United States Supreme Court in arguing, arguably, one of the more important cases ever heard, and certainly one of the most sensitive cases ever heard. I don't think you can argue that. This is a very sensitive case, right? There's no real way to handle this other than with great care. You're dealing with people's lives, and you're dealing with people who are claiming that their privacy is being violated. And in a different time and in a different world, folks, women were treated differently. And this concept that you didn't just attack women was important. And this guy, Jay Floyd, this attorney, stood up. The Chief Justice said, "Mr. Floyd, you may begin." And he said, and I quote, "Mr. Chief Justice, and may it please the court, it's an old joke, but when a man argues against two beautiful ladies like this, they are going to have the last word." Unquote. And they said that you could have heard a pin drop in the Supreme Court chambers. It was met with cold silence. Some people who watched what was that going on thought Chief Justice Berger was going to come right down out of the bench and beat the living crap out of him for making such an incredibly Nicole-Turney statement at a time when it was there. They went through the arguments, and at the end of the first round of arguments, all 7 remaining justices were in perfect agreement that the law was unconstitutional, should be struck down, but on various grounds. Whether it should be struck down because of this, shut down because of that, whatever. They began to work on the drafting of the opinion, and they realized along the way, the guy writing the opinion, which was Blackman, he realized that he couldn't really, because of his own biases and his own beliefs, he wasn't really expressing the true opinion of the court. Yes, they all agreed that the law was unconstitutional and it violated privacy, but was it on the basis of the 14th Amendment, which was the earlier case, or was it on the case of the 9th Amendment, which is what the district court had said? Where did it come from? And he wasn't really expressing all of the opinions that were coming in. By this point, Justices Rehnquist and Powell had been appointed, but they hadn't been part of the first round. And so in May of 72, just a few weeks before the decision would have normally been due, he argued that we should rehear this. Let's do this again. One of the justices, Douglas, he was like, "Oh, no, we're not doing this again." But they all got together and said, "You know what? Let's hear it again. Let's all be on the same page." Texas got smart, and when they reheard it, they sent somebody else other than Mr. Floyd to hear this. And they reheard the whole case. They reheard the other case that was going on at the same time. And it was clear that they had already decided that this was going to happen. And in January, as I said, 22nd, 1973, the same day George Foreman took down Joe Frazier in 2 rounds. Down goes Frazier. Down goes Frazier. The justices decided 7-2 to strike down this law. They did so in an interesting way. They, of course, decided this on the basis of privacy. But They did not feel that the right of privacy came from the Ninth Amendment, which is what the district court had said. The district court said that all the rights that aren't enumerated here are protected by the Ninth Amendment. Therefore, if there's a right to privacy, it must come from the Ninth Amendment, and ipso facto, abracadabra, there's a right to privacy. The Supreme Court, however, decided that was too. See, the problem is we go back to Blackmun. If we just start making up rights that aren't enumerated, then we're a de facto day-to-day convention. And while we might actually be that, we don't want to appear that way, right? So we got to find another reason. We got to find something else. And so they went to the 14th Amendments. 14th Amendment's a concept of personal liberty and restrictions on state actions. They felt that the broad element of the Ninth Amendment's reservation right is broad enough to encompass a woman's decision, but it's that 14th Amendment, because the Ninth Amendment doesn't create any federally enforceable rights, but the 14th Amendment, with its penumbra, with its privacy, with its ability of the court to incorporate, to stop states from doing things that the federal government cannot do, did. They explicitly rejected a right to life argument. They recognized the right to an abortion as a fundamental right included with the guarantee of personal privacy. Therefore, they said that any regulations, any law limiting abortion had to be justified by a compelling state interest, and legislative enactments regarding or regulating abortion had to be narrowly tailored to meet the compelling interest. In other words, Justice Blackmun's position was ultimately accepted in some ways because he wanted strict scrutiny about what this privacy really was. Now, that has left us where we are today, which is, I guess, half the country is angry about it. Half the country loves it. Half the country believes that you have a fundamental right to an abortion. Half the country believes that that's murder. It's probably less than half on each side. Like you, as usual, you probably have this 40-40-20 split on everything. As I've said on numerous occasions, I think abortion is evil. I think it's wrong. The problem comes in when I start applying that to my constitutional beliefs. In other words, do I believe that there is a right to privacy? Yes or no? Does that right of privacy come to me from the Ninth Amendment's protection of unenumerated rights, or does it come from the 14th Amendment's restrictions on the state governments to not be able to do things that the federal government, quote unquote, cannot do? Do you kind of sense the dichotomy there, the arguments as to where this goes? Now, it's easy to look at abortion and become very emotional about it, become very argumentative about it, and say, it's wrong, Dave, or it's a right, Dave. But what if it wasn't abortion? What if it was something else? Now, again, the court ruled that we have a fundamental right to privacy based on the court accepted the Ninth Amendment's argument from the district court, but didn't like that argument. They didn't think it was strong enough. So they went to the 14th Amendment. But if I have this right to privacy found in the penumbra of Griswold, how far does that extend? How far does it go in the world of health? I mean, let's just talk about health for a moment, okay? If an abortion is a surgical procedure, what else is? Right? How many of you listened to the State of the Union the other night, where the president, I heard this, I did watch it. I didn't watch it, glued to it, but I did watch it. The president was talking about experimental treatments. You remember this? And he was talking about Americans should have the right to be able to go after experimental treatments. Well, wouldn't that fit under the health privacy? Wouldn't that fit under the idea that health the government shouldn't be involved with that? That should be between the patient and the doctor? Wouldn't that fit under that that same argument? We argue about, privacy as far as our emails go. Our government just reauthorized its ability to read your phone records if they, quote unquote, want to. We continue to have issues with privacy across the board. How much information can people get about you without a warrant? Wouldn't all of those things fall under the penumbras of privacy? If my health is private, why isn't my pocketbook private? Why isn't my bookshelf private? Why isn't my email private? Why aren't all these other things private as well? When we kind of take away the emotional arguments of Roe v. Wade, and there are some, and again, I'm not trying to play those down. I'm not trying to say, don't pay any attention. That's not what I'm saying. What I am trying to get out is when you take away those emotional arguments, ask the question of ourselves, did the court get it right? Do we, in fact, have a right to privacy, whether you find it in the 9th Amendment's preservation of rights not enumerated, or in the 14th Amendment's penumbra of things that the federal government can't do, so the states can't do it either, in incorporation. All of these arguments have their place and all of them have their time, but I think they get lost and buried in the emotion of Roe v. Wade. And because of that, we lose the argument of the debate, the real discussion of what's the logical extension of this ruling, of the series of rulings that the court came up with. Does it really protect our privacy, or are we narrowly tailoring it to one thing? Yeah, I get it. The court ruled that there's a fundamental right to an abortion. I understand that, but there are other parts of this that I think we're ignoring because, again, we get so lost and so tied up and so angry about the other stuff that's happening. Maybe it's time to kind of sit back and think about some of the other aspects of this and start thinking about, should this really be our primary concern? Those are the things I wonder about. I'm hoping you wonder about them as well. And if you do, you can let me know. Dave at the Dave Bowman Show. You can email me. You can text me, 209-565-DAVE. You can comment on the Facebook page or the Twitter page or whatever else you want, or the show page at plausiblylive.com. Thanks for being here tonight. Thanks for being a part of the first live broadcast of Constitution Thursday in a very long time. And we'll be back, I'm hoping, next week to do this all again. Constitution Thursday is a Slippery Fish Entertainment production for the Podcast 99 Network. Copyright 2018, all rights reserved. For more information or to hear past shows, log on to constitutionthursday.com or facebook.com/Constitution Thursday.
Hey, this is the Scotsman.
And this is Drew.
And coming up on the next Ale Evangelist show, we're going to be talking about local beer.
Are you talking about Uncle Mark's homebrew Dutch treat?
Well, I guess technically that's local, but we're actually talking about craft beer. So join us on the next Ale Evangelist show, where we're going to be talking about local beer in the Central Valley on the Podcast 99, where California talks.